Swayam Prabha. Digital India. Educated India.
Greetings to one and all. Again, I would like to welcome you on the lecture series of Law of Banking and Negotiable Instruments. I am Dr. Rajamaji, Assistant Professor, Faculty of Law, Banaras Hind University, Varanasi. Dear friends, I would like to share with you the very important segments of this part, that is lecture 20, as we have already discussed under the lecture 19, the Foreign Exchange Management Act 1999. So, in the continuations of this lecture 20 is based on that, but in these segments we will discuss the powers and functions of Directorate of Enforcement. Now, when we are talking about the Directorate of Enforcement, it plays a very significant role as far as the Foreign Exchange Management Act 1999. So, before coming to this, just I would like to recall certain things. As yesterday, as in the previous lecture, as I have told you, that there is what is very important that as far as the foreign exchange management, it regulates the foreign trades, it regulates the other affairs of the foreign transactions, and at the same time we have seen the various definitions. As far as the definitions which you will have to always keep in your mind, that is the foreign exchange, the capital transactions, the current transactions, these are the very important the aspects of this part also. So, I am not going to that part, only directly I am coming to the powers and functions of the Directorate of Enforcement. So, to discuss or to understand the what kind of the powers and functions has been provided under the Act to the Directorate of Enforcement. So, in this purpose, the present lecture discusses about the powers and functions of the enforcement of Directorate. To understand the powers and functions of the enforcement of Directorate, some of the powers and functions conferred to the Reserve Bank of India under the Foreign Exchange Management Act 1999. So, under this we will discuss about the powers of the Reserve Banks, and these are the three very important powers which have been conferred to the Reserve Bank of India, and that is very important as far as concerned. Without that, the foreign exchange, when we talk about that, that can be transacted with the authorized person. So, in this regard, the powers have been conferred to the Reserve Bank are, that is, authorizations of persons to deal with the foreign exchange. The second is the issue of directions to the authorized persons, and the third is the inspect the authorized persons. Again, I am telling you that the powers which have been conferred to the Reserve Bank of India, that the one very important power, that who can do or who can transact the foreign exchange business, and the second is that the persons, those who are involved or engaged in such kind of the businesses, that the Reserve Bank can have the right that to issue directions to them, and the third one, that whenever the Reserve Bank thinks that he can inspect them. So, first we will discuss the three very important aspects of as a part of the Reserve Bank of India. Now, under section 10, the provisions has been made that who can be an authorized persons and how they can obtain or how they can start their business. So, for that purpose, the section 10 which talks about the authorized persons, and it says the Reserve Bank may, on an applications made to it in this behalf, authorize any persons to be known as the authorized persons to deal in foreign exchange or in foreign securities as an authorized dealer, money changer, offshore banking unit, or any other manner as it deems fit. Now, in this regard, just let me allow to explain one thing, that any persons who is willing to deal with the foreign exchange, he can file an applications before the Reserve Bank of India, and on the satisfaction of the Reserve Bank of India, that he can authorize any the dealer, the money changer, offshore banking unit, or any other manner it deems fit. The whatever may be the designations, that is the not issue, but any persons who is willing to engage himself for the foreign exchange or in the foreign securities, that he has to file an application before the Reserve Bank of India, and if the Reserve Bank of India is satisfied, that he can issue you can say the permission to them, and that will called as authorized person. And authorizations under this section shall be in writing and shall be subject to the conditions laid therein. So when the person is authorized to deal with the foreign exchange or the foreign securities, at the time of authorizing him, that the everything, that the terms and conditions will be written in that authorization letter. So an authorization granted under subsection 1 may be revoked by the Reserve Bank at any time if the Reserve Bank is satisfied that. So as I have told you, that the Reserve Bank has that power that he can authorize any persons to deal for the purpose of the foreign exchange or the foreign securities. And when he is granting or when he is authorizing to engage that persons to do the foreign exchange, the foreign securities dealings, at the same time that he have the right that he can impose the conditions and the limitations. At the same time, that when the conditions or the limitations that will not followed, then the powers has been conferred under subsection 3 of the Act, and it says an authorization granted under subsection 1 may be revoked by the Reserve Bank at any time if the Reserve Bank is satisfied that. There are the two conditions which have been made. The one, it is public interest so to do. If the Reserve Bank is found that the authorizations which have been granted to someone, and if it is found that it is not good in the public interest, so he can revoke it. And the second condition is that the authorizations persons has failed to comply with the condition subject to which the authorizations was granted or has contravened any of the provisions of the Act or rule, regulation, notification, directions or order made thereunder. So as the first things as I have told you, that is the public interest, that is very important. So the Reserve Bank had the discretion that the authorizations which have been granted, that can be withdrawn or revoked in the public interest. And the second one, as I have told you, that the authorizations that has been granted with certain conditions, and at the same time when you find that the authorized persons is not complying all the conditions which is made at the time of authorizations, or if in any time see the provisions of any act, the rules, regulations, notifications, directions or the order made thereunder, if it is not followed, at that time that it can be revoked. But when he is revoking, then naturally there the provided clause says, provided that no such authorization shall be revoked on any ground referred to in clause B unless the authorized persons has been given a reasonable opportunity of making representation in the matter. That is very important. As I have told you that although the power has been conferred in non-compliance of any of the, you can say the rule, regulation, notification, directions or order made thereunder, if it is not complied, then the Reserve Bank reserve the power, or you can say the discretion lies to the Reserve Bank of India that he can revoke it. But before revoking, that the provisions has been made under the provided clause, and it says the provided that no such authorization shall be revoked on any ground referred to in clause B unless the authorized persons has been given a reasonable opportunity of making a representation in the matter. That means the opportunity will be provided to the authorized persons before revoking it. Further, it says that an authorized person shall in all his dealings in foreign exchange or foreign security comply with such general or special directions or orders as the Reserve Bank may from time to time think fit to give, and except with the previous permission of the Reserve Bank, an authorized person shall not engage in any transactions involving in any foreign exchange or the foreign security which is not in conformity with the terms of his authorizations under these sections. It is very important, the provisions has been made under subsection 4, and it clearly mentions that the whatever you can say the terms and conditions which he made at the time of authorizations, the person says only that he is entitled to do their dealings within that limitations, and unless and until that the authorized person shall not engage in any transactions involving any foreign exchange or foreign security which is not in conformity with the terms of his authorizations under this section. That means it's a very clearly mentioned that beyond that the authorized persons cannot go. and the authorized persons can engage himself in such kind of the dealings which is authorized to do at the time of authorizing him. The subsection 5 further says an authorized person shall, before undertaking any transactions in foreign exchange on behalf of any person, requiring that the persons to make such declarations and to give such informations as well reasonable, satisfy him that the transactions will not involve and is not designed for the purpose of any contraventions or evasion of the provisions of this act, or any rule, regulation, notification, direction, or order made thereunder, and where the said persons refuses to comply with any such requirement or makes only unsatisfactory compliance therewith, the authorized person shall refuse to writing to undertake the transaction, and shall, if he has reason to believe that any such contraventions or evasion as aforesaid is contemplated by the person, report the matter to the Reserve Bank of India. So, as a authorized persons, when he is dealing anything, that all the informations, whatever may be, which is made under the provisions of this act or the rules, if anything which is in contraventions of it, it is the duty of the authorized persons that all sorts of informations must be furnished to the, or must be put before the Reserve Bank of India. And the finally, the subsection 6 of section 10, which talks about that any persons other than the authorized person who has acquired or purchased foreign exchange for any purpose mentioned in the declarations made by him to authorized person under subsection 5 does not use it for such purpose, or does not surrender it to the authorized persons within the specified period, or uses the foreign exchange so acquired or purchased for any other purpose for which purchase or acquisitions of foreign exchange is not permissible under the provisions of the act, or the rules or regulations or directions or order made thereunder, shall be deemed to have committed contravention of the provisions of the act for the purpose of this section. So, subsection 6 very clearly mentioned that any persons other than an authorized person, who has acquired or purchased foreign exchange for any purpose mentioned in the declaration made by him to authorized person under subsection 5, does not use it for such purpose, or does not surrender it to the authorized persons within the specified period, or uses the foreign exchange so acquired or purchased for any other purpose for which purchase or acquisitions of foreign exchange is not permissible under the provisions of the act, or the rules or regulations or directions or order made thereunder, shall be deemed to have committed contravention of the provisions of the act for the purpose of this section. So, the subsection 6 of section 10, it very clearly mentioned that the declarations is very important. When the declarations has been made, and that the foreign exchange or the securities, whatever may be, that has to be, you can say, the expend in that way, failing which, again it is talking about that within the specified period that you will have to inform to the authorized persons, and if he is not doing that, that will comes under the contraventions of the provisions of this act, and there is a provisions for the penalty for it. Now, the sections 11, which is very important, and the sections 11 is talking about the Reserve Bank's power to issue directions to authorized persons. As you have seen that the authorized persons, when we are talking about, it is taking birth by the Reserve Bank of India itself. Unless and until the Reserve Bank is authorizing someone, the persons is not in a position to dealing with the foreign exchange or the foreign security. So, the first and foremost thing is that under section 10, that he must obtain the permission from the Reserve Bank of India by putting an application to the Reserve Bank of India to be an authorized person. So, once he got that, then we have seen under section 10 that how he has to perform, and at the same time we have seen that if in case of the non-compliance, that the authorized persons, the permission that is a subject matter of revoke. So, the section 11 is very important. The section 11 empowers the Reserve Bank of India to issue directions to authorized persons. Let us see what says. Subsection 1 of section 11 says the Reserve Bank may, for the purpose of securing compliance with the provisions of this Act and of any rules, regulations, notifications or directions made thereunder, give to the authorized persons any directions in regard to making of payment or the doing or desist from doing any act relating to the foreign exchange or the foreign security. Again, I am repeating it. As I have told you that the Reserve Bank is the sole authority to regulate or the control the affairs of the authorized persons. So doing that, it is very important the Reserve Bank must have some sort of powers. So that power has been conferred under section 11 of the Act, through which he can have a right to issue directions to the authorized persons. So the subsection 1 of section 11 very clearly mentioned the Reserve Bank may, for the purpose of securing what? That is compliance with the provisions of this Act, of any rules, regulations, notifications, directions made thereunder, give to the authorized persons any directions in regard to making of payment or the doing or desist from doing any act relating to foreign exchange or foreign security. Further, the subsection 2 again it states that the Reserve Bank may, for the purpose of ensuring the compliance, that is very important, they ensuring the compliance with the provisions of this Act or any rule, regulation, notification, directions or order made thereunder, direct any authorized persons to furnish such information in such manner as it deems fit. So, by reading these two provisions, subsection 1 and subsection 2, if we will see that the Reserve Bank has given the power under which that when he is authorizing any persons to dealing with the foreign exchange or the foreign securities, at that time he has to ensure that whether the persons with what conditions or the limitations that the authorizations has been made, whether he is complying or it or not. So for that purpose, the section 11 has specifically conferred the powers to the Reserve Bank of India to issue directions to the authorized persons. So the Reserve Bank may, for the purpose of securing compliance with the provisions of this Act, of any rules, regulations, notifications or directions made thereunder, give to the authorized persons any direction in regard of making a payment or the doing or desist from doing any act relating to foreign exchange or the foreign security. Now further, subsection 3 says in contraventions of these provisions, it provides some sort of, you can say, the punishment or it penalizes. So the subsection 3 of section 11 talks about it. Let me allow to read out. The provision says where any authorized persons contravenes any direction given by the Reserve Bank under this Act or fails to file any return as directed by the Reserve Bank may, after giving reasonable opportunity of being heard, impose on the authorized person a penalty which may extend to 10,000 rupees, and in the case of continuing contraventions, with an additional penalty which may extend to 2,000 rupees for every day during which such contravention continues. Let me again repeat, when we are talking about that, as I have told you, the powers which have been conferred under section 11, the very important things that the Reserve Bank has, in other way we can say that how the limitations or the directions which has been made at the time of granting, or you can say providing or accepting as the authorized persons, at that time it is duty towards the Reserve Bank of India to ensure that the compliance is made or the compliance is doing by the concerned authorized persons. In non-compliance, the subsection 3 provides that where an authorized person contravenes any directions given by the Reserve Bank under this Act or fails to file any return as directed by the Reserve Bank may, after giving reasonable opportunity of being heard, impose on the authorized person a penalty which may extend to 10,000 rupees, and in the case of continuing contraventions, with an additional penalty which may extend to 2,000 rupees for every day during which such contravention continues. So the contraventions means non-compliance of the directions which have been made by the Reserve Bank of India, either under section, you can say at the time of granting the compulsory, that is the persons who is authorizing him under section 10, or that additional any kind of, you can say, the directions which he made by exercising the power under section 11, if it is contravenes, that the penalty has been imposed to the authorized persons in contraventions of any such directions given by the Reserve Bank of India under this act, or even if he fails to file any return as directed by the Reserve Bank has the discretion that after giving reasonable, you can say, the opportunity of being heard, impose on the authorized persons a penalty which may, the penalty amount is, that is the 10,000 rupees in case of the any kind of the contraventions, and if the such contravention is continuing further, then an additional penalty which may extend to 2,000 rupees for every day during which such contraventions continue. So there is a huge penalty, we can say, that has been made in non-compliance of the provisions of the Reserve Bank of India to an authorized persons, and the authorized persons have the opportunity that he can put forward before the Reserve Bank of India that what are the reasons that why he has not complied it. So the reasonable opportunity is given to the authorized persons, but after hearing that or after providing the reasonable opportunity that if he is found that the non-compliance or he contravenes any sorts of the, you can say, the provisions of this act, then it's very clearly mentioned under subsection 3 that the authorized persons can be penalized, and that penalty which may extend to 10,000 rupees, and in case of the continuing contraventions with an additional penalty which may extend to 2,000 rupees for what? For every day during which such contraventions is continues. Now, the powers has been conferred to the Reserve Bank of India, as it is very important that how you can ensure that whether the Reserve Bank, the directions which has been issued, or the rules which is talking, or the any kind of, you can say, the additional the instructions or order which has been made by the Reserve Bank of India towards any specific, you can say, the authorized persons, how it can be ensured. So for that purpose, it is very important the Reserve Bank must have some sort of powers to inspect the authorized persons. So the inspections power has been provided under this act, the Foreign Exchange Management Act 1999, and that's a section 12 that talks about. The section 12 talks about the power of Reserve Bank to inspect authorized person. So when we are talking about the inspect authorized persons, then we have seen that under section 11 the authorized persons can be penalized. But as my question that when we are talking about how this can be done, so to know whether he is contravening any of the provisions, so for that purpose the section 12 plays a very significant role, or it will be better to say that it's a very pertinent part of this act that which conferred the power to the Reserve Bank of India to inspect authorized person. So subsection 1 of section 12 says the Reserve Bank may at any time cause an inspection to be made by any officer of the Reserve Bank especially authorized in writing by the Reserve Bank in this behalf of the business of any authorized persons as may appear to it to be necessary or expedient for the purpose of, again I am talking about that the Reserve Bank may at any time is very important. There is no any kind of the limitations. At any time he can cause an inspection to be made by the Reserve Bank of India, and that can be done through any officer of the Reserve Bank especially authorized in writing to the Reserve Bank in this behalf of the business of any authorized persons as may appear to it to be necessary or expedient for the pursuit of. What are the three very important things has been meant? Verifying the correctness of any statement, information or particulars furnished to the Reserve Bank. Again I am repeating it. The first and foremost thing to ensure that the powers has been conferred to conduct inspection, it can be inspect. The inspect power has been conferred to the Reserve Bank of India. That the first and foremost thing is the verifying the correctness of any statement, information or particulars furnished to the Reserve Bank. The second thing is obtaining any information or particulars which such authorized persons has failed to furnish on being called upon to do so. And the third thing is very important, securing compliance with the provisions of this act or of any rules, regulations, directions or orders made there under. It's very important. Let me again explain the three things, because unless and until we understand that why this is required. The section 12 is very pertinent, as I have told you. This conferred the power to the Reserve Bank of India to conduct inspect towards the authorized person. So, the subsection 1 of section 12 very clearly mentioned that the Reserve Bank may at any time cause an inspection to be made by any officer of the Reserve Bank, especially authorized in writing by the Reserve Bank in this behalf of the business of any authorized persons as may appear to it to be necessary or expedient for the purpose of it. The three things will be taken into consideration. The first one, it is talking about the verifying the correctness of any statement, information or particular furnished to the Reserve Bank. The information which is provided from, or you can say from the end of the authorized persons, that whether that information is correct or not, how it can be ensured. So, for that purpose the inspections can be done, and it empowers under section 12. It says the verifying of the correctness of the statement, information or particulars furnished to the Reserve Bank. And the second thing, it is talking about obtain any informations or particulars which such authorized persons has failed to furnish being called upon to do so. If any kind of the additional information or whatever may be the information which asked to submit to the Reserve Bank of India, so if any such kind of information, whether it was submitted by it or not, that will be a subject matter of inspection. And the third very important thing is that the securing compliance with the provisions of this act or of any rules, regulations, directions or orders made thereunder. So, the three things will be ensured that by the Reserve Bank to conduct and inspections at any time when it feels necessary. The further subsection 2 says, it shall be the duty of every authorized persons, and see that the very important thing, see that the word which is used under subsection 2, and it says it shall be the duty of every authorized person, and where such authorized persons is the company or a firm, every director, partner or other officer of such company or firm, as the case may be, to produce to any officer making an inspections under subsection 1 such books, accounts and other documents in his custody or power, and to furnish any statement or information relating to the affairs of such person, company or firm as the said officer may require within such time and in such manner as the said officer may direct. Now, let me tell you the subsection 2. The subsection 2 is talking about the persons, whoever may be the authorized persons. So, whoever may be responsible, as far as concerned that when we are talking about the firm of a company, then who are the responsible? It says the every director, the partner or other officer of such company or firm, as the case may be, to what? They are compelled to assist, it is better to say, they assist to what? To produce any officer making an inspection under subsection 1, such books, accounts and other documents in his custody or power, and to furnish any statement or information relating to the affairs of such person, company or firm as the said officer may require within such time and in such manner as the said officer may direct. So, this is very important, that whatever the assistance is required from the persons who is conducting inspections, the persons who is appointed under subsection 1 of this section 12, and that is very important, that the persons who is possessing any sorts of the documents or the any other kinds of the records, that it's the duty towards that persons that he has to provide or he has to submit or he has to give such information whenever the said officer is required within such time and within such period. So, accordingly that he has to comply it. Now, I am coming to the second part of it. The second part of it, that is the Directorate of Enforcement. So, it's the very important, which is, as we have seen, that the authorized persons, then we have seen that the powers has been conferred to the Reserve Bank of India for the to that to provide the additional information, and at the same time that whether the duty has to be performed by the authorized persons, whether he is performing or not. For the purpose, what are the requirement? The requirement is that the inspections can be done, and the purpose is that it will ensure that whether all the directions or whatever may be asked to deposit, whether that were you can say the compliance by the authorized persons or not. For that purpose, there is a provisions under section 12 that and inspections can be conducted by the Reserve Bank of India. The very beautiful thing is that at any time, that means once the Reserve Bank conducted in inspections, it doesn't mean that further he cannot do. At any time, it's free to do or to conduct such kind of information. Now, I am talking that when we are talking about the adjudicating authority, for that purpose, the adjudicating authority we must have that how it can be done. So, for this purpose, we will have to see the Directorate of Enforcement. As when concerned the Directorate of Enforcement, the provisions have been made under the Foreign Exchange Management Act 1999 under section 36, and the section 36 provides the provisions for the Directorate of Enforcement. So, let us see what says the section 36. When we are reading the section 36, subsection 1 says, the central government shall establish a Directorate of Enforcement with a director and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purpose of this act. Again, I am repeating it. If you will go through the subsection 1 of section 36, which is talking about the Directorate of Enforcement. So, the powers has been conferred to the central government under subsection 1 of section 36, and it states that the central government shall establish a Directorate of Enforcement. That means the power is conferred the central government to establish the Directorate of Enforcement. How it will function, who will carry forward the establishment which is established by the central government as a Directorate of Enforcement, then the answer is that the affairs will be carried out with the help of director. The first word is that is the director, and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purpose of this act. So, the directors and the other officers, those who will be appointed, so they will be called the officers of enforcement. So, by reading subsection 1 of section 36, that central government shall establish a Directorate of Enforcement, and the Directorate of Enforcement with carried its affairs with the help of director and such other officers or class of officers as the central government thinks fit, and these officers will be called the officers of enforcement for the purpose of this act. The very important things, again, it is made under subsection 2 of section 36, which says, without prejudice to the provisions of subsection 1, the central government may authorize the Director of Enforcement or an additional Director of Enforcement or a special Director of Enforcement or a Deputy Director of Enforcement to appoint officers of enforcement below the rank of an Assistant Director of Enforcement. So, in other way we can say the central government gives some sort of powers to the persons, means the directors, that is very clearly mentioned. It says that without prejudice to the provisions of subsection 1, the central government may authorize, that is very important. Who is authorizing? The central government is authorizing. To whom? The Director of Enforcement or Additional Director of Enforcement or a Special Director of Enforcement or a Deputy Director of Enforcement, for the purposes that what? To appoint officers of enforcement, and that is below the rank of an Assistant Director of Enforcement. So, if we will read in the different way, then we will find that the central government conferred some sort of the powers to whom? To Director of Enforcement, an Additional Director of Enforcement or a Special Director of Enforcement or a Deputy Director of Enforcement. What kind of the powers? That they will have a powers to appoint officers of enforcement to whom? Below the rank of an Assistant Director of Enforcement. That means that they cannot appoint any kind of additional directors of enforcement, or they cannot appoint the Special Director of Enforcement, they cannot appoint the Deputy Director of Enforcement, but they have a power that they can appoint the officers of enforcement the below the rank of Assistant Director of Enforcement. So the below the rank of Assistant Director of Enforcement, any officers that will not be appointed by the central government directly, that will be done through whom it is authorized, the Director of Enforcement, or an Additional Director of Enforcement, or a Special Director of Enforcement, or a Deputy Director of Enforcement to appoint officers of enforcement below the rank of Assistant Director of Enforcement. Further, subsection 3 says, subject to such conditions and limitations as the central government may impose, an officer of enforcement may exercise the powers and discharge the duties conferred or imposed on him under this act. So that it is talking about the subject to the such conditions and limitations as the central government may impose. The central government has a discretion power that he can impose. An officer of enforcement may exercise the powers and discharge the duties conferred on imposed on him under this act. So it will work on the basis of it. So the further when we'll looking towards it, then it's a very important things which has been made under this act, which I like to share with you. That is the, let me come to this provisions. So I was talking about the limitations which has been imposed, and that can be imposed on any enforcement officer, and that can be discharged according to the limitations which has been imposed under subsection 3 of the act. Then further when we are talking about that the powers of search, seizure, etc. that has been provided under section 37 of the act. So let me allow to discuss about it. The subsection 1 says the Director of Enforcement and other officers of enforcement not below the rank of an Assistant Director shall take up for investigations and contraventions referred to in section 13. And further it says, without prejudice to the provisions of subsection 1, the central government may also, by notification, authorize any officer of class of officer of any central government, state government, or the Reserve Bank not below the rank of Under Secretary to the Government of India to investigate any contraventions referred to in section 13. So the section 13 is talking about the investigations, and that will be done as far as concerned that the search and seizure power is conferred to the officers who has been appointed under section 37 of the act. Now the officers referred to in subsection 1 shall exercise the like powers which are conferred on income tax authorities under the Income Tax Act 1961 and shall exercise such powers subject to such limitations laid down under that act. As far as concerned that what kind of the powers they will exercise are the similar powers which has been conferred to the income tax authority under the Income Tax Act. In the same way, the officers, those who have been appointed as far as concerned the search and seizure according to section 37, they will exercise the same kind of powers as I have told you, that the powers which is conferred to an income tax officer under the authority of, or you can say the income tax authority which has been provided under the Income Tax Act 1961. Now, apart from that, section 37, the very specific provisions has been made under section 37A, and the provision says the special provisions relating to the assets held outside India in contravention of section 4 of the Act. Let us see what says. Subsection 1 says, upon receipt of any information or otherwise, if the authorized officers prescribed by the central government has reason to believe that any foreign exchange, foreign security, or any immovable property situated outside India is suspected to have been held in contraventions of section 4, he may, after recording the reasons in writing, by an order seize value equivalent situated within India of such foreign exchange, foreign security, or immovable property. By reading these provisions, it is very clear that the special provisions relating to the assets which are held outside India, and these are the contraventions of the section 4 of the Act. And upon the receipt of any information or otherwise, if the authorized officers prescribed by the central government has reason to believe that any foreign exchange, foreign security, or any immovable property situated outside India is suspected to have been held in contravention of Section 4, he may, after recording the regions in writing, by an order, seize value equivalent situated with India of such foreign exchange, foreign security, or immovable property. Provided that it says, no such seizure shall be made in case where the aggregate value of such foreign exchange, foreign security, or any immovable property situated outside India is less than the value as may be prescribed. So that the provisions has been made that the value which will have that cannot be provides unless and until it is prescribed. Again I am repeating it. The provided that no such seizure shall be made in case where the aggregate value of such foreign exchange, foreign security, or any immovable property situated outside India is less than the value as may be prescribed. It's very important that the search and seizure for such things which the foreign security or the foreign exchange or any immovable property which is situated outside India, it is not always a subject matter of search and seizure unless and until the value is exceeds. The value which is prescribed, if the value is not exceed that cannot be a subject matter of search and seizure. Further, subsection 2 very clearly mention that the order of seizure along with relevant material shall be placed before the competent authority appointed by the central government, who shall be an officer not below the rank of Joint Secretary to the Government of India by the authorized officer within the period of 30 days from the date of such seizure. Again I am repeating it, it's very important. The first thing, as I have told you, that every such property is not a subject matter of the search and seizure. For that purpose, you will have to find that it is the quantum or the quantity that is above the prescribed manner. That might be the foreign exchange, that might be the foreign security, or that might be any immovable property which is situated outside India. What we can say that is very important, that it has to be C, that is the it is above the prescribed value. And the second thing which is very important as far as concerned this, it says the order of seizure along with the relevant material shall be placed before the competent authority appointed by the central government, who shall be an officer not below the rank of Joint Secretary to the Government of India by the authorized officer within a period of 30 days from the date of such seizure. That means any seizure which has been made, that is very important, that has to be produced before the authorized officer, and that authorized officer is not below the rank of Joint Secretary to the Government of India, who is been the competent authority as far as concerned, who has been appointed by the central government for this purpose, and that has to be produced within 30 days from the date of such seizure. Further, subsection 3 says the competent authority shall dispose of the petition within a period of 180 days from the date of seizure by either confirming or by setting aside such order after giving an opportunity of being heard to the representatives of the Directorate of Enforcement and the aggrieved person. Again I am repeating it. The very important provisions which he made, as I have told you, that before the competent authority, that the seizure, whatever may be the material that might be in terms of the foreign exchange or in terms of the foreign security or in terms of the immovable property, that has to be produced before the competent authority within 30 days. Once that is presented before the competent authority shall dispose the petition within a period of 180 days from the date of seizure by either confirming or by setting aside such order after giving an opportunity of being heard to the representatives of the Directorate of Enforcement and the aggrieved person. So it's the duty towards the competent authority. The competent authority must dispose of the petition within a specified period, and that period has been specified, that is 180 days from the date of seizure by either confirming or by setting aside such order after giving an opportunity of being heard to the representatives of the Directorate of Enforcement and the aggrieved person. And The subsection 4 further says the order of the competent authority confirming seizure of equivalent assets shall continue till the disposal of adjudication proceedings, and thereafter the adjudicating authority shall pass appropriate directions in the adjudication order with regard to further actions as regards to seizure made under subsection 1. Again I am repeating it. Subsection 4 very clearly mentioned that the order of the competent authority confirming seizure of equivalent assets shall continue till the disposal of adjudication proceedings, and thereafter the adjudicating authority shall pass appropriate directions in the adjudications order with regard to further action as regards to the seizure made by under subsection 1. But provided that it says, if at any stage the proceedings under this act, the aggrieved person discloses the fact of such foreign exchange, foreign security or immovable property and brings back the same into India, then the competent authority, the adjudicating authority, as the case may be, on receipt of an applications in this regard from the aggrieved person and representatives of the Directorate of Enforcement shall pass an appropriate order as it deems fit, including setting aside the seizure made under subsection 1. So, the provided clause is very important, and the provided clause states that if at any stage of the proceedings under this act, the aggrieved persons discloses the fact of such foreign exchange, foreign security or immovable property and brings back the same into India, then the competent authority or the adjudicating authority, as the case may be, on receipt of an applications in this regard from the aggrieved person and representatives of the Directorate of Enforcement shall pass an appropriate order as it deems fit, including setting aside of the seizure made under subsection 1. Further, subsection 5 says, any person aggrieved by any order passed by competent authority may prefer an appeal to the appellate tribunal. Again I am repeating it. Subsection 5 made a very specific provisions, and it says that any persons aggrieved by any order passed by the competent authority, then it says that if he is aggrieved one, he can prefer an appeal before the appellate tribunal. Now, before going or before discussing the appellate tribunal, let us see some of the powers which have been conferred under section 38. And section 38 says empowering other officials. Apart from that means the officers, those who have been appointed under section 36 of the act, the section 38 is talking about empowering other officers. Let us see what it says. Subsection 1 of section 38 states that the central government may, by order and subject to such conditions and limitations as it thinks fit to impose, authorize any officer of customs or any central excise officer of any police officer or any other officer of the central government or a state government to exercise such of the powers and discharge such of the duties of the Directorate of Enforcement under this act as may be stated in the order. Now let me, it's very clearly when we are reading the section 38 is talking about the empowering other officers. That means the officers, those who are appointed under section 36, apart from that, the section 38 is talking about the different kind of officers with the powers has been conferred to the central government. And subsection 1 very clearly states that the central government may, by order and subject to such conditions and limitations as it thinks fit to impose, authorize any officer of customs or any central excise officer of any police officer or any other officer of the central government or a state government to exercise such of the powers and discharge such of the duties of the Directorate of Enforcement under this act as may be stated in the order. By reading the provisions, we can say that the central government has a power that with a particular order that he can put some sort of, because the conditions and the limitations as it thinks fit, and he can impose that he can authorize any officer of customs or any central excise officer or any police officer or any other officer of the central government or a state government to exercise such of the powers and discharge such of the duties of the Director of Enforcement under this Act as may be stated in that order. So, the other officers are empowered through Section 38. The central government can make an order by putting limitations or the restrictions, and these officers that might be the central government, or these officers belong to the state government, that might be the customs officer, that might be any other officers, they are empowering under Section 31 subsection 1, they can discharge the functions of the Enforcement Directorate. Further, subsection 2 states that the officers referred to in subsection 1 shall exercise the like powers which are conferred on the income tax authorities under the Income Tax Act 1961, subject to such conditions and limitations as the central government may impose. So, like the previous the sections which we talk about, that what kind of the powers can we exercise. So, then we have seen the officers, those who have been appointed under Section 36, they can exercise the powers like the authority, the powers which is exercised or powers which is conferred the income tax authorities under the Income Tax Act of 1961. The similar kind of powers, the officers, those who are empowering to act or to do or to extend their services as the Enforcement Directorate, they will have the same kind of powers, they will exercise the same kind of powers as when we are reading this particular provisions of Section 38 subsection 2, then it says that the officers referred to in subsection 1 shall exercise the like powers which are conferred on the income tax authorities under the Income Tax Act of 1961, subject to such conditions and limitations as the central government may impose. Now, the very important the segment which I like to share with you is the 2-3 things which we have learned. The first thing we have learned that who is the authorized persons. Then we have seen that what kind of the powers has been conferred to the Reserve Bank of India to regulate the authorized persons. Then we have seen the under Section 36 of the Act. What is that? That we have seen the Director of Enforcement, and again we have seen that the other officers are also as a part of the Directorate of Enforcement. Now, what they will do, so for that purpose we will have to read the Section 13, the Section 13 which is talking about the penalties. So, Section 13 says the penalties, and subsection 1 states that if any person contravenes any provisions of this Act, any person's terms has been used, contravenes any provisions of this Act, or contravenes any rule, regulation, notification, direction or order issued in exercise of the powers under this Act, or contravenes any of the conditions subject to which an authorization is issued by the Reserve Bank, he shall, upon the adjudication, be liable to a penalty up to thrice the sum involved in such. Let me explain again that contravention, in such contraventions when such amount is quantifiable, or up to 2 lakhs rupees where the amount is not quantifiable, and where such contraventions is a continuing one, further penalty which may extend to 5,000 rupees for every day after the first day during which the contravention continues. Let me explain it. The penalties, when we are talking about, the penalties has been, the provisions has been prescribed under Section 13 of the Foreign Exchange Management Act of 1999. The subsection 1 very clearly says that if any person contravenes any provisions of this Act, or the contravenes any rule, regulation, notification, directions or order issued in exercise of the powers under this Act, or contravenes any conditions subject to which an authorization is issued by the Reserve Bank, he shall, upon adjudication, be liable to a penalty up to thrice sum involved in such contravention when such amount is quantifiable, or upon the 2 lakhs rupees where the amount is not quantifiable, and where such contraventions is continuing one, further penalty which may extend to 5,000 rupees for every day after the first day during which the contravention continues. Let me tell you that any persons whose act is in contravention of any of the Act, then the two kind of penalty has been prescribed under this section 13 subsection 1. The one, if it is quantifiable, then the thrice amount, whatever maybe the amount is involved. Suppose 1000 is involved, then you have to penalize the 3000 rupees, or up to 2 lakhs rupees where the amount is not quantifiable. In case of if the amount is not quantifiable, then the penalty can be imposed on you, that is 2 lakhs rupees, and where such contraventions is continuing one, further penalty which may extend to 5000 rupees for every day after the first day during which the contraventions continues. Now, if any person who is found to have acquired any foreign exchange, the foreign security or immovable property situated outside India of the aggregate value exceeding the threshold prescribed under the provision of subsection 1 of section 37A shall be liable to a penalty up to 3 times of the sum involved in such contraventions, and confiscations of the value equivalent situated in India, the foreign exchange, the foreign security or immovable property. Further, subsection 1B says, if the adjudicating authority in a proceedings under subsection 1A deems fit, he may, after recording the reasons in writing recommended for the initiation of the prosecutions, and if the Director of Enforcement is satisfied, he may, after recording the reasons in writing, may direct prosecutions by filing a criminal complaint against the guilty persons by an officer not below the rank of Assistant Director. Further, 1C, subsection 1C says, if any person is found to have acquired any foreign exchange, foreign security or immovable property situated outside India of the aggregated value exceeding the threshold prescribed under the proviso to subsection 1 of section 37A, he shall be, in addition to the penalty imposed under subsection 1A, punishable with the imprisonment term which may extend to the 5 years and with the fine. The further, subsection 1D says, no court shall take cognizance of an offence under subsection 1C of section 13 except as on complaint in writing by an officer not below the rank of Assistant Director referred to in subsection 1B. Further, subsection 2 states that any adjudicating authority adjudging the contraventions under subsection 1 may, if he thinks fit, in addition to any penalty which he may impose for such contraventions, direct that any currency, security or any other money or property in respect of which the contraventions has taken place shall be confiscated to the central government, and further direct that the foreign exchange holdings, if any, of the persons committing the contraventions or any part thereof shall be brought back into India or shall be retained outside India in accordance with the directions made in this behalf. Now, the adjudications and appeal, which is very important. In a very brief, I would like to mention here that the appointment of the adjudicating authority that has been made under section 16. Section 16 subsection 1 says, for the purpose of adjudications under section 13, the central government may, by an order published in the official gazette, appoint as many officers of the central government as it may think fit as the adjudicating authorities for holding an inquiry in the manner prescribed after giving the persons alleged to have committed contravention under section 13 against whom a complaint has been made under subsection 3. Hereinafter in these sections referred to as the said person a reasonable opportunity of being heard for purpose of imposing any penalty, provided that where the adjudicating authority is of opinion that the said person is likely to abscond or is likely to evade in any manner the payment of penalty if levied, it may direct the said persons to furnish a bond or guarantee for such amount and subject to such conditions as it may deem fit. Further, the subsection 2 says, the central government shall, while appointing the adjudicating authorities under subsection 1, also specify in the order published in the official gazette their respective jurisdiction. Subsection 3 further says that no adjudicating authority shall hold an inquiry under subsection 1 except upon a complaint in writing made by any officer authorized by general or a special order by the central government. That is very important. And further, subsection 4 says the said persons may appear either in person or take the assistance of legal practitioner or chartered accountant of his choice for presenting his case before the adjudicating authority. So, the assistance can be taken by the said persons when he is appearing before either persons, or take the assistance of the legal practitioners or the chartered accountant who can present their case before that. So, every adjudicating authority shall have the same powers of a civil court which are conferred to the appellate tribunal under subsection 2 of section 28. All proceedings before it shall be deemed to be the judicial proceedings within the meaning of the section 193 and 228 of the Indian Penal Code 1860, and shall be deemed to be civil code for the purpose of sections 345 and 346 of the Code of Criminal Procedure 1973. I am coming to the appellate authority. The appellate authority, there are two or you can say the three kind of, you can say, appellate authority. And the first appellate authority, the appeal to the special director. The appeal to the special director appeals that provisions have been made under section 17. It says the central government shall by notification appoint one or more special director appeals to hear appeals against the orders of the adjudicating authorities under this section, and shall also specify in the said notification in the matter and places in relation to which the special director appeals may exercise jurisdiction. So, it will better to say that it is the first appellate authority, and that is known as the special director's appeals, and that provisions have been made under section 17 of the Act. So, the any persons agree by an order made by the adjudicating authority being an assistant director of enforcement or deputy director of enforcement may prefer an appeal to the special director appeals. And further it says the every appeal under subsection 1 shall be filed within the time limit has been prescribed, that is 45 days from the date on which the copy of the order made by the adjudicating authority is received by the aggrieved person, and it shall be the such form verified in such manner and be accompanied by such fee as may be prescribed. What I think, it says provided that the special director appeals may entertain an appeal after the expiry of the said period of 45 days if he is satisfied that there was sufficient cause for not filing within the specified period. And again the provisions have been made that dispose of on the receipt of an appeal under subsection 1, the special director appeals may, after giving the parties to the appeal an opportunity of being heard, pass such order thereon as he thinks fit, confirming, modifying or setting aside the order appealed against. Now, the special director appeals shall send a copy of the every order made by him to the parties to the appeal and consult the adjudicating authority. And finally, it says the special director appeals shall have the same powers of the civil court which are conferred under the appellate tribunal under subsection 2 of section 28 of the Act. What are these? The all proceedings before him shall be deemed to be the judicial proceeding within the meaning of the section 193 and 228 of the Indian Penal Code 1860, and shall be deemed to be the civil code for the purposes of sections 345 and 346 of the Code of Criminal Procedures of 1973. Now, the second is the appellate tribunal. The provisions have been made under section 18, and section 18 says the appellate tribunal constituted under subsection 1 of section 12 of the Smugglers and Foreign Exchange Manipulators Forfeitures of the Property Act 1976 shall on and from the commencement of the part 14 of the chapter 6 of the Finance Act 2017 be the appellate tribunal for the purposes of this act, and said the appellate tribunal shall exercise the jurisdiction, powers and authority conferred on it by or under this act. So, how the appeal can be made before the appellate tribunal? The provisions have been made under section 19 of the Act, and it's a very the specific things have been made. The savage otherwise provided in subsection 2, the central government or any persons aggrieved by an order made by the adjudicating authority other than those referred in the subsection 1 of section 17 or the special director appeals may prefer an appeal to the appellate tribunal. What are these? It says provided that any persons appealing against the order of the adjudicating authority or the special director's
appeals, levying any penalty, shall wish, filing the appeal, deposit the amount of such penalty with such authority as may be notified by the central government. Provided further that it says, where any particular case the appellate tribunal is of the opinion that the deposit of such penalty would cause undue hardship to such person, the appellate tribunal may dispense with such deposit subject to such conditions as it may deem fit to impose, so as to safeguard the realizations of penalty. That the provisions is made that the every appeal under subsection 1 shall be filed within a period of 45 days is very important from the date on which a copy of the order made by the adjudicating authority or the special director's appeals is received by the aggrieved persons or by the central government, and it shall be in such form, verified in such manner, and be accompanied by such fee as may be prescribed. It further says, provided that the appellate tribunal may entertain an appeal after the expiry of the said period of 45 days if it is satisfied that there was sufficient cause for not filing it within that period. Now again, I would like to mention here that the time limit has been prescribed, that the appeal can be preferred before the appellate tribunal, and that has to be made from the date of the decisions, that is within 45 days of the adjudicating authority, or you can say the special director appeals, whichever may be, that appeal can be preferred before the appellate tribunal within that set period. But if the someone fails to prefer an appeal within that stipulated period of 45 days, then the powers has been, discretion power has been conferred to the appellate tribunal that he may entertain even after the expiry of that period. On receipt of an appeal under subsection 1, the appellate tribunal may, after giving the parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying, or setting aside the order appealed against. And further it says, the appellate tribunal sends said a copy of every order by it to the parties to the appeal and the concerned adjudicating authority or the special director appeals, whoever may be there. Further it says, the appeal filed before the appellate tribunal under subsection 1 shall be dealt with by it as expeditiously as possible. Any and endeavor shall be made by it to dispose of the appeal finally within 180 days. That is very important, within 180 days from the date of receipt of the appeal, provided that where any appeal could not be disposed of within the said period of 180 days, the appellate tribunal shall record its reasons in writing for not disposing of the appeal within the said period. Finally, it says, the appellate tribunal may, for the purpose of examining the legality, propriety, or correctness or any order made by the adjudicating authority under section 16 in relation to any proceeding on its own motion or otherwise, call for the records of such proceedings and make such order in case as it thinks fit. Now, the last appellate authority which is available, that has been made under section 35 of the Act, and it says, the any persons aggrieved by any decisions or order of the appellate tribunal may file an appeal to the High Court within 60 days, from the date of communications of the decisions or order of the appellate tribunal to him, or any questions of law arising out of such order. It says, provided that the High Court may, if it satisfies that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within the further period not exceeding 60 days. So, at the end, just I would like to mention that although this the Foreign Exchange Management Act 1999 is very important to regulate the foreign exchange, to regulate the foreign securities, or it will be better to say that the Reserve Bank of India plays a very significant role to control over the foreign affairs that might be related to the foreign exchange or the foreign security. Thank you. Thank you very much.